I mean, if you read what the first motion is, it's a witch hunt. It's based on a lot of false accusations. It's based on letters from a person that is documented has mental ill problems, and yet, she and her lawyer have chosen to come after me with all these ridiculous things.
Are you talking about your present wife?
The two wives got together to conspire to put these motions together. So yes.
Is that your second wife or your first wife?
Susan Remar is my second wife. That's who's filed motions. Jenny Remar is who she's conspiring with to bring these motions against me.
I see. Okay, so that's your first wife.
Second. Third wife.
Third.
Yes.
I'm trying to see which one of your three wives put your dog down and put the dog in the refrigerator. Now,
Jenny Remar, my third wife.
Your third wife did that.
Yep. And who this case is, a lot of their motion is based on a letter she wrote, statement she wrote, and a police report that she filed falsely.
All right, I have two motions that have been filed in this matter. First on my screen is Michael Remar. Mr. Remar, good morning.
Good morning.
And next on my screen, on behalf of Susan Remar, Attorney Courtney Sierra. Ms. Sierra, good morning.
Good morning, Your Honor.
And finally, the defendant in this matter, Susan Remar. Ms. Remar, good morning.
Good morning, Your Honor.
I have read both of your motions, Ms. Sierra. Did you get a copy of both of those, Mr. Remar?
Yes, I did.
All right. Then anything you want to add? I read everything. So anything you want to add, highlight, accentuate, Ms. Sierra? Ms. Sierra, I'll turn things over to you.
Thank you, Your Honor. I did have an opportunity to review Mr. Remar's responses. The second response I received yesterday afternoon, and in reviewing that with the parties, there are some agreements here. So it seems like there is an agreement for the children to go to counseling from the first motion. And so that seems like a resolved issue to me. The other thing that was in the second response was that there was an agreement to go to the FOC for mediation. Granted, there were some additional requests for time to be paid for that, but overall, I think that there is an agreement for mediation with the FOC because that will limit the cost for the parties. It seems to me to be appropriate for the parties to go to mediation and to talk about some of these issues, because ultimately these issues that we brought before the court revolve around communication between the parties, which the communication really is not that good. And it is disheartening and frustrating for my client that she has to file motions to get movement on some of this stuff. She shouldn't have to file a motion to get a response about, therapy. That it shouldn't be required. So really, I think that sending this over to mediation for the parties to work on some of these issues, specifically the car insurance, responding to messages, and access to health insurance information would be best suited to be dealt with the parties at mediation. In reviewing the responses, Mr. Remar's communication to Ms. Remar is hostile. It's hostile, it's aggressive, it's angry, and I think it would be beneficial for not just Mr. Remar, but the full family for him to participate and complete some anger management counseling. I think in doing that, mediation would be successful. Perhaps with a couple of those under his belt, mediation will be better suited for these parties. Further, I've had an opportunity to speak to my client about different ways that we can get this on track for these kids. And one of the things we discussed was co-parenting therapy for these parties so they can work on their communication to each other. Overall, the responses have a theme that my client is trying to manipulate the system. She's trying to manipulate all of these things. The reality is there's a communication issue, and these things need to be dealt with. My client is not trying to manipulate anything. She's not requesting for time to be taken. She's not doing any of that. She's asking for solutions. She's trying to figure out solutions to make things work better for these kids. So, Your Honor, I would request that the court order that Mr. Remar participate in complete anger management counseling, that the parties participate in co-parenting counseling, and that the parties go to the front of the court to discuss some of these additional issues regarding insurance and responses to communication. And that the children begin therapy with both parties being involved, but it sounded like there was an agreement to that.
Thank you. Let me state, Mr. Remar, when did you file your responses to these motions?
Yesterday. They didn't give me much time, Your Honor. They literally sent me these the other day. In fact, both times that these motions have been filed right near holidays, right before the weekend, and gave me very little time to put these together. Last time I came to court, they were an hour and 20 minutes late, and then apparently had a conflict of schedules, and so took that day off of work, took another day off of work today. They just haven't given me much time, but I filed those responses yesterday, sent them to all the parties in email, and dropped them off down at the court system for you.
Well, you know what happens, right? The court rule provides that these are supposed to be delivered to the court 3 days before your motion, because understandably, I don't have either one of them.
Either one of the responses?
That's correct.
Well, the other one was delivered 4 weeks ago.
Don't have it. I don't know how you got it to me. Usually the best way to do that is to bring it down along with a judge's or referee's copy.
That is exactly what I did.
Yeah, I don't know. Sometimes things get lost in the shuffle with the holidays and such. But it's my understanding, Ms. Sierra, we adjourned this once before, did we not?
Yes, Your Honor. The original motion was actually served to Mr. Remar on November 27th. The re-notice went out on December 9th, and then the second motion with these additional issues that we were asking to be included with like a mediation, that was actually served to Mr. Remar on December 30th via email. So these are not motions that I have sent in the last minute, in the 11th hour, anything like that.
Okay. Well, I didn't receive them. If you want to get those to me, Mr. Remar, I'd be happy to do that. Happy to review those. But I have a few questions about this. One of the biggest questions I have is because one of the things I always tell people that come in front of me, no matter what it is, that everybody has to follow court orders. Ms. Sierra has to follow court orders. Both of you do. I do. We all do. So I guess my question is, our family wizard, it doesn't look like you're following that order. Am I mistaken in that?
Well, Your Honor, I try the best I can do to keep up with our family wizard. In my responses, I indicated what had happened on one particular instance. My phone had fallen into the water and it wouldn't hold an app. So I had 7 or 8, 9, 10 days where I couldn't stay in any app. It wouldn't stay in. I explained that to Susan, but she decided to write this anyways. The other thing is,
hang on. Do you have a laptop or another computer?
I have an iPad, but it reads our family wizard at an angled diagonal. It won't read it vertically. It won't read it up straight up and down. It will only read it on an angle, not even if I turn the iPad the other way. So my phone is how I communicate. And ironically, in my responses, I also had documentation that showed Ms. Remar for multiple days not answering OFW as well. So I think it's pretty ironic that she's going to say he doesn't respond and sometimes goes days at a time when she does the same, especially when she knows I'm gone for a weekend or with the kids on a vacation. She'll write multiple mass messages and demand answers. And then if I don't answer, she just writes the same question tons and tons of times. For instance, she wrote about the health insurance, and I had explained to her the health insurance program's fine. It gets re-upped every November. It's been re-upped again this November. The cards are coming in the mail. All you have to do is go to the doctor and say, here's my kids, this is the program, and they'll pull it up. I am still waiting for insurance cards myself. I explained that to her, but she continued to just write the same message over and over and over on OFW. Finally, I just stopped responding because it's the same message. I've already answered it. Asking the same question 12 times after I've answered it doesn't deserve a response.
Is she an authorized user on that?
No, she's not an authorized user. And I don't want her to be an authorized user because in the past, she has attempted to commit insurance fraud by billing me for the beginnings of the insurance program each year, not realizing that court order says she's supposed to cover the first 400 and some odd dollars, but attempts to bill me, sends me bills through OFW, sends me bills in Venmo. And I finally had to have my lawyer get involved and explain to her that's not how this works. There is a cost out of her pocket before the copay scenario takes over. I wish you had my responses, Your Honor, because they're very thorough. I delivered the responses to the first motion about a month ago in person down at the court system, and delivered the other ones yesterday because, like her attorney had said, they just sent me the second motion December 30th. It's not a lot of time to prep and prepare during the holidays for today's court session. And at the last court session we went to, they showed up an hour and 20 minutes late and then said they had a scheduling conflict.
You need more time?
No, I'm done. I've had a chance to put the responses together. I wish you had them. I don't understand why you don't have the first ones. I understand why maybe you wouldn't have the second ones. They were just delivered yesterday.
Okay, well, that's sometimes that happens, and the best way to get something to me anyway is to get it directly to my office, maybe either an email to my clerk or something along those lines.
Well, I had emailed it to the clerk's office, to the county, to the folks that my lawyer had indicated I emailed it to. But yesterday when I was down there, the gal at the clerk's office said they don't accept emailed responses. So I'm not sure why.
You've now dropped your lawyers, not by name, twice. Do you plan on involving your lawyer?
My lawyer actually had said to me after the first motion, I had put together my responses and whatnot. I'm trying to keep costs down. She said, you really don't need me. Your responses make sense. She thinks that the first motions that have been filled out are ridiculous and that my responses are a great response to those. I mean, if you read what the first motion is, it's a witch hunt. It's based on a lot of false accusations. It's based on letters from a person that is documented has mental ill problems. And yet, she and her lawyer have chosen to come after me with all these ridiculous things.
Are you talking about your present wife?
The two wives got together to conspire to put these motions together. So yes.
Okay, so your first wife or your second wife,
the children's mother, yes, Susan.
No, I'm talking about I'm trying to figure out who you're saying is mentally ill.
So Jenny Remar, the person who in their first case,
and that's your second wife, right? Is that your second wife or your first wife?
Susan Remar is my second wife. That's who's filed
Okay.
motions. Jenny
Okay.
Remar is who she's conspiring with to bring these motions against me.
I see. Okay, so that's your first wife.
Second. Third wife.
Third.
Yes.
Okay, I just want to make sure I get all the.
Was married once for 10-ish years, was married to Susan for 15-ish years, and was married to Jenny for 2.5.
So the letter that your third wife wrote, which I reviewed, you're saying I should discount that because your third wife is mentally ill.
Well, in my responses, it states that. I mean, she literally has said some ridiculous things about, me having dementia, that I've got some sort of blunt head injury. It is just absolutely ridiculous, bold-faced lies and false statements. Yet Susan and her lawyer have chosen to use those things against me. Literally, Your Honor, she put my dog down on a Sunday and stuffed him in the refrigerator so I would find him when I got home. That is the sort of thing we're talking about. That is who Susan and her lawyers have decided to bring on as a partner in these motions against me.
Well, hang on a second. You've lost me again. So
without my responses, it's probably really hard for you to follow what we've got going on here.
Well, that's why I'm trying to fill in the blank. I'm trying to see which one of your three wives put your dog down and put the dog in the refrigerator. Now,
Jenny Remar, my third wife.
Your third wife did that.
Yep. And who this case is, a lot of their motion is based on a letter she wrote, statement she wrote, and a police report that she filed falsely.
Okay. I've read some of the responses on the Our Family Wizard, and they are somewhat inappropriate.
Your Honor, if you had my responses, you'd know why. I'm not an angry person, but since day one of this divorce, I've had to defend myself against attacks, against trying to take the kids from me, manipulation of schedules. For instance, during COVID, the school system in its infinite wisdom decided that if there were split family homes, they would only bus to one home. So Susan, because she has physical custody, decided that even though she works part-time from home and lives much closer to the schools than me, she would cancel my bus route. So she canceled the bus route to my home to make it more difficult and harder for me to be able to be a good father to my kids. That required me to have to get up extra early with my daughter because I had an elementary age student, a middle school student, and a high school student. Massive manipulation of schedules in the morning to get the kids to schools, and then massive manipulations in the afternoon to be able to work around my work schedule to pick up the kids and get them where they had to be. She did that in hopes that I would just bring the kids to her so she could have more parenting time in the morning, more parenting time in the afternoon. What I ended up doing was selling that house and moving into the same neighborhood as Susan so that the kids could be on the same bus schedule. Shortly after I moved into the neighborhood, Susan and her friend, who was a bus driver and friends with the bus coordinator, decided that they would make an effort to make my bus stop illegal. I had to fight very hard to fend off that attack.
Sorry, hang on a second. Your bus stop illegal?
Yes. A bus stop that's at the cul-de-sac at my house that's been a bus stop for 35 years.
So if you brought your kids to that bus stop, you'd be arrested?
No, they tried to say it was an illegal bus stop because it was unsafe. And that was their language that they used. It's an illegal bus stop because it's unsafe, which isn't true. But again, I was backed into a corner and I had to make sure that I stuck with it and, protected my family and my ability to get my kids to and from school so that I could be a better earner. I'm taking care of two households here, my own household and Susan's. So I had to become a little bit cantankerous with the busing people to be able to keep my bus stop, even though it had been a bus stop for 35 years. But Susan and her friends who were bus drivers tried to have it deemed unsafe.
And when you were banned from school property, were you being cantankerous then too?
I actually wasn't banned from school property. That's a bold-faced lie in their motion. What actually happened is, and I'll tell you,
history. If you tell me you have not been banned from the property by this individual, that's pretty easy to figure out. I mean, I don't need the whole long and short of it.
Well, I'll tell you what. I
don't own the property. Hang on a second, Mr. Lee. I don't own the property, so I can't ban you. They can ban you. And you're saying they didn't ban you. So I guess that's an issue we'll have to dig out at the next time we get together.
Yeah, we'll need to, because I contacted, so in her letter, in the letter that Ashley Gregory wrote, who is the cheerleading coach, she says that, in her letter, because it's my second offense, I've been banned from the property. And she's run this through the athletic department. Well, one, there was no first offense. All I did last year is write a letter that said the photographer that they hired for school pictures was screaming at a couple of fathers for taking pictures of their daughters all done up in their cheerleading outfits prior to the photo. And I said, you probably should talk to your photographer about that, because it really sends a bad message. That was it. That was the only thing. No word back, nothing, no offense, no conversation. This year, the junior high cheerleading director developed a program. They sent out an email that said they were only going to communicate with one parent, the parent that signed the cheerleader up and paid for it. So that was all they were going to do. And I said, this policy is discriminatory against split family homes. It's discriminatory against a lot of fathers, because, to be honest, most of these are moms that sign their daughters up for cheerleading. And I said, I think this is a bad policy. At the cheerleading photos, I asked Ashley, my daughter's cheerleading coach, if I could have a minute of her time. And I said, hey, this policy's wrong. This isn't safe for the girls. What happens if in the middle of the day, you determine you're going to change the practice location, or you're going to change the practice time? I have no way of knowing that if my daughter is in my custody that day. I think it's wrong. And she said, well, it doesn't matter what you think. That's the policy we've made. And all I said was, under my breath, this policy's bullshit. That was it. And I wrote a letter to the head coach.
So you told the cheerleading coach that their policy is bullshit, strong letter to follow.
Yeah,
right? And
I wrote a letter. And you probably haven't seen the letter, because you didn't see my responses, or have you seen the letter? Very professionally written about.
How would I see the letter if it was in your response that I don't have?
I didn't know if maybe they had sent it to you.
Okay. I think that's what I'm going to do, Mr. Remar, because you're right. This somewhat puts me at
can I interject real quick too, just about that session? I called the athletic director's office at the school, and they said they have no information on anything from Ashley Gregory, the cheerleading department. They have no letter, no email, no text, no phone call. And what I find it ironic is that conversation that I had was on August 28th. I wrote the letter on August 28th. No response, nothing, not a phone call, no email back, zero. But she says in her letter that I didn't like her response, which she never responded to me. Then on October 14th, she writes an email to Susan saying these preposterous things about this outburst and a second offense. What's happened here, and I can prove it. I wish you had my response, is that every school year, Susan systematically goes to the teachers, to the coaches, to any parents of children that our kids make friends with, and tries to paint this picture of, I'm a bad guy, I'm a bad dad, I'm hostile. And she's this super mom. And it's been happening for 4 years now. And I have proof, text messages from fathers who've written me and said, hey, just so you know, here's what your ex-wife is doing. And here's what she's trying to paint a picture of you as. I can prove these things true. So
Okay.
when you say my
enough.
OFW responses,
Enough.
okay.
I got the gist of things. Ms. Sierra, anything you want to add?
Your Honor, I would just like to clarify. I misspoke earlier. This was not served to him on December 30th. I apologize. It was actually served to him on December 26th. So it was timely. It was consistent with court rules. I think that what I've heard today is a lot of excuses for bad behavior. I don't think that my client should be faulted for receiving information from people that isn't highly concerning. Candidly, I believe that these motions are relatively tame and asking for very appropriate relief considering Mr. Ramar's conduct and how he behaves and how he conducts himself. So I would request, Your Honor, that you order that the children go to counseling, that the parties are ordered to go to mediation with the FOC to discuss some of the communication issues, car insurance for the children. I do think that it would be appropriate for the court to order that Ms. Ramar be added as an authorized user so she can get information about health insurance. And I would request that Ms. Ramar be ordered to attend anger management. He seems to have problems with everybody. At a certain point, Your Honor, if there's a common denominator among a lot of different things, it's, anger problem, anger issues, conflict. And it seems like Mr. Ramar is the common denominator here. It's not my client. So I would also request co-parenting therapy. My client does not want to do, she doesn't have this big agenda. That's not what she's trying to do. Mr. Ramar's position of speculation of what she's doing and what he thinks she's doing and all that, it's preposterous. She wants to get things on track and get communication where it needs to be so these people can co-parent their kids.
The last question I have, because I want to make sure I get this right. Is it pronounced Ramar or Reamer, or how do I pronounce your last name, Mike?
It's Reamer.
Reamer. Okay,
Yes.
thank you. All right. So, Ms. Sierra, I'm going to have you prepare the following order. First of all, that mediation is ordered pursuant to MCR 3.216. The parties will agree on a mediator, and if they can't, Ms. Sierra is to contact the dispute resolution clerk for Kent County, and they will provide the next mediator in the queue. The second provision of this order is that both parties shall comply with all the previous orders of our family wizard, and in the event that it is not complied with, either party can bring an order to show cause with Judge Gottlieb. I want to reply within 24 hours. I don't know if you have the tone meter on this, Ms. Sierra, because the tone meter should be added to this, because that will prevent some of these messages from being the manner in which they're being done. I believe the third element is the children will be enrolled in counseling with an agreed upon counselor, or each party shall submit 2 names and I'll pick one. And I want to make sure that the counselor is covered by by their insurance. Insofar as the insurance is concerned, I'm going to require that insurance cards be given to the defendant.
They already are. They're always given to her.
Oh, please don't interrupt me, Mr.
Okay.
Please. They will be given to her And in the event that that's not sufficient, Ms. Sierra, then if and when we come back, you can explain to me why she needs to be made an authorized user. So I'm reserving that issue. I believe the parties should also attend co-parenting counseling. Once again, with a counselor of their choice, and in the event they can't, you can submit 2 names to me and I'll pick somebody. And also I want to make sure that's coincided with their insurance. I am going to reserve the issue of anger management at this point. I want to see if we have to come back again on that issue. I want to see Mr. Reamer's responses to some of these things before I pull the trigger on that, but I will reserve that so that we can also do that. I'm also going to reserve $1,500 in attorney's fees, not to be paid, but to be reserved pending compliance with all of these matters. So far, I've heard a lot about how this affects the parties, but you have both made the conscious choice to bring into this world a 14-year-old and a 9-year-old. And it would probably behoove you to try and take a look at this from their perspective. If I did anything, whether you're right or wrong, Mr. Reamer, I don't know. Whether you've been banned or not, I don't know. But all I know is that my children, and I also raised a cheerleader, would be mortified by just this coming up. And just remember, folks, they're 14 and 9. In 4 more years, and I'll use initials KCR, can come down and obtain a complete copy of this court file and read every little bit of what's going on here. So I suggest that we call a truce and start acting as reasonable co-parents. Ms. Sierra, is there any questions about what I need this order to say?
No, Your Honor, I do not have any questions.
Okay, thank you. Then if we have to come back, I want to specifically make sure that I see Mr. Reamer's responses, because I think all of that is very important. Ms. Sierra will, and if you need time frames, I'm talking, I want these matters done within the next 21 days. Counseling, those types of things, because I don't want to wait too much longer here. So thank you both very much. I wish you'd both have a great weekend, but try and look at this from a kid's perspective. This is not helping them at all. So thank you very much. We're adjourned.
Thank you, Your Honor.
Thank you, Your Honor.